segment of The Power of Money. I'm your host, Michelle Graves, internationally and nationally known as the Money Lady, bringing over 36 years of actual hands-on experience and expertise in the areas of finance, money, insurance. My goodness gracious, and I'm officially a senior at this point in my life, a part of the 77 million Americans that constitute the baby boomers. So without further ado, I'm going to move quickly into today's interview with an attorney at law who specializes in legacy planning, estate work, illustrious career, and she's a female. And she's also a Christian, yes, which I love. So Nancy Roberson will be my guest for the next hour. Please sit down, take out a pen because you're going to learn some things, and be prepared to enjoy today's segment. Thank you for joining us today. And how are you, Miss Roberson?
Well, thank you.
I'm so glad that you're here and that you consented with your incredibly busy schedule to give me some time. Where do we want to begin? Do you want to give me some background information about you and what you're doing?
I can do that. As you said, I'm a lawyer and I've been in private practice for over 25 years. I believe that I'm doing God's work in the world, and primarily in the area of estate planning, probate, and trust law. I am a certified specialist in the state of Ohio in those areas, and I'm pleased to serve the gamut of people who need our services.
That's amazing. Over the span of 25 years, I'm sure you've experienced a lot in this very specific specialty. Can you share with me, and for our viewers as well, why a person would want to see you as a specialist as opposed to a general practitioner?
I can give you my own example, Michelle.
Okay.
Giving you a little bit more background about me. When I was 26 years old, I was been married to David for 5 years, and he was diagnosed with cancer, and treated. And so I realized that we did not have wills, and I'd not had much experience with lawyers. So I called the Dayton Bar Association and was told that the Bar Association had a lawyer referral service, and would I like for the Bar Association to schedule my appointment with a lawyer who would do wills? And I said, well, sure. I mean, can't get any better than that. So David and I went to a nice gentleman. We were in and out of his office in 20 minutes.
20 minutes?
20 minutes. He asked us what we would like for him to do for us. We said we needed wills. And he said, what kind of wills do you want? And we said, I'm not sure. And he said, well, how about simple wills? And we said, well, that sounds good.
That sounds simple.
So he asked us a few questions.
Okay.
And we came back, I think it was a couple weeks later, and signed our wills. David died the following summer, and I hired that lawyer to handle David's estate. David's estate was simple, and he did a good job, didn't charge me a lot. That was a good thing. I started law school not long after that, and when I got out in the Dayton legal community, I learned that that man was a bankruptcy lawyer, and that there were a lot of things that could have been addressed in the process of planning for David and me, even with our simple lives, and being a young couple and not having much money at that time in our lives. But any lawyer who is licensed in Ohio is allowed to write a will, because writing a will is a legal procedure. But he did not address the gamut of estate planning that we could have used, given that David had already been treated for a life-threatening illness, and so on.
Did you have children as a result of that union?
We did.
Oh, that's a whole nother area, right?
Yes, and that was my primary fear as a young mother. Here, David's cancer diagnosis gave him a fairly long prognosis, but I was concerned about what would happen to Amy. She was just a year old at the time, And I said, we have got to get something in place in case I die too.
Right, right.
So that was the primary focus of getting our simple wills, is making sure that we had guardianship listed for Amy.
Now, if you had to do that again, tell me how you would have done it.
I find that, and I tell people because they ask, how can I locate quality legal services? And I usually say, try to locate a certified specialist in the area of practice. You know, we women who have had children, we didn't go to an orthopedic surgeon to deliver our babies.
No, we did not.
That's the example that I give about going to a specialist. And although any licensed lawyer in Ohio can write a will with regard to estate planning services, a person needs to go to a certified specialist in the area of estate planning, probate, and trust law.
Now, what is a certified? You've used this term several times. Can you tell me what that is?
It is a credential that is given by the Ohio State Bar Association for going over and above in this area of practice. For example, we have to take more continuing legal education courses. We had to take an exam which was like a mini bar exam in order to, and pass it, in order to be certified as a specialist. We have a periodic peer review that is in the form of references that are submitted to the Ohio State Bar Association. And we have to practice, about half of our practice hours have to be dedicated to this area. Now, Michelle, I do want to say this. I know a couple really excellent estate planning lawyers, including my mentor, who is not a certified specialist, and they've had their reasons for not becoming. I wouldn't tell people to not go to them. In fact, there have been times we've made referrals to them when there's been a conflict of interest or we haven't had time or that sort of thing. But in general, for the stranger who is starting on her own, that's how I would recommend finding a lawyer in whatever area of law one needs advice.
Well, it's kind of like, if I can make an analogy, it's kind of like medical doctors or medical practitioners. You can go to a family practice physician, but then many times, particularly today, you're referred on to a specialist. If you have cancer, you're referred to an oncologist. If you have heart conditions, you're referred to a cardiologist. And the family practitioner kind of is your generalist. You don't expect him to have the requisite skills and knowledge base. And I would think that that's the same thing in your industry, which actually is a good thing. If you've got bankruptcy, you need to go to a person who specializes in that type of law. But I do know that with estate planning, particularly where we're heading as a society with the complexities of multiple marriages and children and all kinds of emotional challenges with handicapped and special needs people, you do need to have someone who has that high level of training or additional training to handle your affairs properly. Wouldn't you agree?
I would agree. And Michelle, so many people believe, a lot of people know that they should have a will, even though the statistics still aren't real good in terms of how many people have wills. But just like when I was so young, when with my first husband, David, I did remarry 7 years after David died.
Okay.
And God has blessed me with a wonderful husband now for 28 years.
Oh my goodness, that is wonderful.
But we did, you know, the expression, you don't know what you don't know.
The gray zone. Yeah.
We didn't know what we didn't know. And I didn't know as a 26-year-old that I needed, or I would have needed, power of attorney for David. I did not know that I was going to need health care directives for David. I certainly didn't know I was going to have to plan his funeral. And those are the kinds of things that we specialists talk about. We go deeper. In fact, our office, we get into things like identity theft and protecting your credit and even putting ICE numbers in your cell phones and things like that, all kinds of areas of planning in order to be protected.
That is so outstanding. That is so very, very outstanding. So what drew you into this area of specialty? Why didn't you just do general practice? Was it your own experience?
You know, my life is like a tapestry, and the front makes sense. You turn it over and you see all these gnarly knots and hanging strings in the back. You know, no, I did not go to law school because David had died, and I thought I wanted to do estate planning. Actually, I took a series of courses at law school that seemed interesting. For example, in law school, we all had to take income tax. Well, the income tax professor was great, so I took him for some other classes, and he was teaching the estate planning track. And I took almost every course he taught. That was Professor Dale Searcy, and he knows I'm just crazy about him, and I give him so much credit and respect him so much for helping me to become who I am today. It was really only after, I did not know what I was going to do even after I graduated. I was still kind of scratching my head. I knew that I was supposed to go to law school. I knew that God had led me to law school. But when I got out, I just didn't know. So I worked for another lawyer for a couple years who had a med mal practice and did some writing and appellate work for her, and did not find that as satisfying and as gratifying. It wasn't feeding my soul. And then I had the occasion to meet an investment advisor who actually, I needed some life insurance myself, so he sold me some term life insurance, and he asked me if I'd be interested in reviewing some trusts. There was an investment company that was giving people free trusts if they purchased a certain investment with them, but the trust needed to be reviewed, and so I said sure, and so I started doing that, and then remembering my training from law school and Dale Searcy, that there is more to estate planning than just having a trust. You have a will that coordinates with the trust, and goodness, people need powers of attorney too, and healthcare directives. And so I started doing work. That's really where I started.
Really?
It really is. And from that, people liked what I did, and they started referring their family and friends, and then that investment advisor told other investment advisors about me, and that is really how my reputation spread, and how I have the practice that I have today.
That's an amazing story.
Well, it really is.
Particularly about feeding your soul,
yes,
and doing something that you feel is God-led. That's
absolutely.
so important.
And then, in addition to helping people plan, I do a lot of speaking too.
Really? Okay.
Because there's a teacher. My undergraduate degree is in Indiana at Indiana University, and I'm particularly excited this time of year because of basketball and my team's doing well. But I got a degree in English, and so writing is a strength of mine. But what do you do with an English degree? So I got a secondary teaching certificate, and learned teaching concepts, and really feel a passion about teaching people about what they don't know. And so I do a lot of speaking, and that feeds my soul as well.
That is so wonderful. So you've been in this specialized area for 25 years,
Right.
Is that correct?
Right.
And so you do all aspects of estate planning, from doing a will to also doing your trust work and more complex trust instruments as well.
That's correct.
With people,
yes.
but you also do it from a holistic perspective.
Absolutely.
So you look at other things and family relationships.
Absolutely, and we do what I call values-based estate planning.
Tell me what that's about.
It's really important for us to know what a client's goals are. We send out a folder of information when people inquire about our services that contains a 21-page checklist to complete. And on the second page of the checklist is a listing of goals that people can number by hierarchy.
Okay.
And so I discuss those goals with clients, you know, before we ever get into the nuts and bolts of what their documents are going to look like. You know? And so, for example, we'll talk about their net worth, and because we really need to know a client's net worth in order to guide the client in the proper into the proper documents.
Okay.
So, for example, the laws have changed a lot in the last year.
I want to talk to you about that too, because the
Ohio-
laws have changed.
Yes.
You let me know about that.
Ohio no longer has an estate tax. We
Yes.
used to write lots of trusts for people to minimize Ohio estate tax. Well, Ohio no longer has an estate tax.
And is that perpetual law or is that by legislation?
It's by legislation.
So we
yeah.
might have it again
Yes, yes.
as the economy continues to muddy.
Yes.
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 I'm just saying that
Yes.
if it's not codified, it can be changed, correct?
Well, it is codified.
Okay.
I mean, it's by statute.
Okay.
It was the law was passed actually in the summer of 2011.
Okay.
And then became effective January 1st of 2013. So it wasn't case law.
Okay.
Governor Kasich. It was
Okay.
law that Governor
Okay.
Kasich signed. But, you know, statutory law can always be changed by our legislatures as the times and needs change.
Yes,
Yeah.
okay.
And that's also true of our federal laws as well. During the fiscal cliff legislation, the federal estate tax exclusion amount was increased to $5 million
Right.
and made permanent. You know, but what does permanent
What
mean?
does that mean
You
in
know?
Washington? Yeah.
What does that mean in Washington? So going back to the values-based estate planning, if clients have great wealth, we need to know about that so that we can advise them on whether they need trusts or other legal instruments in order to minimize the estate taxes. Also, asset protection planning has become very important to people, not only from the standpoint of protecting their assets from their creditors, or others' creditors, the spouse's creditors, but also in the area of nursing home costs. And so,
big area.
big area. And
Big
so,
area.
so if someone comes in to us and has a $6 million estate and does not have long-term care insurance, we will really carefully explore what's most
Why?
important to you. Well, why to begin with? You know, why? But then, do you want to do trusts to minimize the estate taxes, or do you want to do asset protection planning, or what's you know, commonly known as Medicaid estate planning? They are really can be diametrically opposed goals, you know, where it may involve transferring assets into an irrevocable trust or into a limited liability company owned by the children. So we have to get to those values and those goals first. And certainly, and I would say probably foremost for me, beyond anything, is, and my clients hear me say this a lot, is preserving the integrity of their families. You know,
I love that term, preserving the integrity of your family.
Yes, yes. For example, I had a meeting last week with some lovely people. Just instantly liked them. And the wife has been her mother's agent under her power of attorney, and not so much live-in caregiver, but directly responsible for her mother for 12 years since her father died.
Okay.
And longevity in the family. Well, now mother's doing her own estate plan, husband and wife.
Yeah.
And she doesn't want her children to have the burden that she's had for 12 years. So we explored who she would name among her children to be in charge. We even talked about, and this was kind of creative because I don't see myself as a real creative person. I'm a good innovator, but sometimes I need help with creativity. But I said, well, shoot, let's put in the power of attorney that perhaps we could list years. Year 1 through 5, son John would be power of attorney. Year 5 through 10, or whatever. You know, on a rotating
successorship.
Successorship. Yes. But and then there was an issue of most of the kids get along, but some of them have a little tension. And how is that going to work out? Should we maybe name all of the children and then have management by committee and have a tiebreaker? And I also suggested, and I usually preface these comments by, now, you know, don't shoot the messenger, but if you're really concerned about preserving the integrity of your family, maybe you don't want to name any of them. maybe you want to name an independent
Exactly,
person.
an outsider, an attorney or
Somebody
yeah.
like, or if you're going to have a trust set up, name a bank, as the trustee, and just take that burden off of your children. Then let them be mad at the third party.
Yes,
instead of each other.
Right. I do know from past experience in this field as well that that's a hot area. That's a touchy area because in every family there are personalities.
Yes. Yes.
There are personalities.
We're all different.
We're
yes.
all different. And when you start talking about aging and dying, those personalities tend to really, really go there. And the child that's been so quiet may turn out to be the child that's got a strong opinion about something. So that's a very key area. I can certainly see your creativity in that. I had never thought about successorship with powers of attorney.
Oh my goodness, we wouldn't, well, I won't say I won't write a power of attorney without at least 2 successors. I think I've written a couple in my life because my staff and I, and there are 2 other lawyers on staff now with me, we insist that there be a first, second, and third choices because you never know. I mean,
so the first may decline and then it goes to the second.
Yes.
Second declines, goes to the third. It's not based upon the death of the first or the second. It's just.
It can be based on a lot of different variables,
okay.
but
you can
generally
write all
that's
of that
it.
in.
Yes, you can write all that in.
Okay, that's nice. That's a flexible agreement then.
Designations of fiduciaries, as we call them, the people who are going to be in charge, whether it's the trustee for the trust or the executor for the estate or the agent for the power of attorney. Those names can be very flexibly written. There can be co-fiduciaries, there can be alternating fiduciaries. You can have them serve for limited periods of time. Yeah.
So let me ask you this question. Does a person have to have significant net worth? Because I know some of the viewers are saying, well, I don't have $1 million. I don't even have a $500,000 or $250,000. Does that negate the relevancy and the importance of having a will?
Oh, Michelle, it makes having a will more important. My experience has been that the most costly estates to administer are those that have fewer assets and no will. And one of the reasons why the estate administration is more costly is because unless the beneficiary is a surviving only child, for example, if mom dies, father has already died, and there's an only child, that child can be appointed as the administrator of the estate and not have to post bond, which is a type of insurance policy that has to be purchased to protect the estate from theft or loss. But if there is more than one, if there are more than one heirs to the estate, then whoever applies to be appointed as the administrator, and that's the label, that's a technical legal label that is used for the fiduciary who is in charge of the estate when there's not a will, then that administrator has to post bond. And
personal? Out of their own revenue? They have
no, it will come out of the estate funds.
Okay.
But bond can be quite expensive, and that bond applies to not only the estate, but then if there is money to be distributed to a minor, a person who's under 18, then a bondable guardian is going to have to be appointed. And by bondable, I mean you have to pass a credit check.
Oh, my word.
Okay, so that's another reason to have a will, because wills usually waive bond for the executor and for the guardian. But if the bond is not waived, then the guardian has to pass the credit check, or the executor has to pass the credit check. And I can tell you, I've ended up as the estate.
What a mess.
Yeah, it is
what
a mess. It is a mess. And it's costly. It's very costly, especially in this day and age, if there's real estate to sell and it's not selling quickly, and we have to, if the estate takes longer than a year, then we'll have to get another year's worth of bond. So that alone is a reason to get a will.
I had no idea because, well, as I'm processing what you're saying, if there are children involved and you die without a will, known as intestate,
Correct.
for the benefit of viewers, and there are children, who is the guardian of the children?
Who's the guardian? Well, if there's a surviving parent,
Yes.
then the surviving parent is presumed to be the guardian of the estate and guardian of the person.
Okay.
The probate court, which the probate court is the division of the county common police courts in Ohio, which is responsible for administering estates. Upon application, the probate court will appoint a guardian of the estate for the minor's money and funds, whatever the minor would inherit.
The court will.
The court will. Now, the parent, the surviving parent, does not have to be appointed guardian of the person of that child, because the biological parent is already that child's guardian by Ohio law.
Okay.
But it's really, if there's a surviving parent, it's only in the context of an inheritance that surviving parent will need to make an application if her or his child is inherited money.
And a minor.
A minor, yeah. It's not presumed that the parent gets to control that money. As I said, there has to be an application.
Oh my word.
And if the parent is not creditworthy, well,
oh my gosh.
Well, yeah.
What?
So yes. So another reason why it's important to have a will, so that if the surviving parent would be the appropriate person to manage that child's money, then the surviving parent can do that without having to pay the bond. And there's actually a way to write the will so the child's money doesn't have to be supervised by the court either.
Really?
Yes.
Because I have encountered more than my share of those situations where the court is administering money for a minor.
Yes.
Because proper paperwork had not been put in place when the parents were alive. And now you've got these children, and essentially, I think the guardian even has to post.
The guardian of the estate has to post bond.
Right.
And then ask permission for expenditures.
Goodness gracious.
Yeah, even if it's the child is living with the parent. Here in Montgomery County, in Dayton, Ohio, where this is being filmed, our court's position for many years has been, if possible, to save what the minor has inherited for college, because it is the surviving parent's responsibility to support that child.
Yes.
You know, to provide food, clothing, and shelter, support. But if there are needs above and beyond that the surviving parent cannot support, then that's where asking the court for permission to spend that money comes in.
So that money is put in a segregated account, I presume, for the benefit of the child.
Correct, yes.
Okay.
Whether it's a bank account, whether it's invested, the Ohio Revised Code has statutes that govern how fiduciaries, how guardians can invest.
And all because they did not take care of this simple thing that is so important.
Right, right.
Which is having a will.
Right, that's correct.
I want to sidebar, and I'm going to speak directly to my audience right now. Many of you statistically are raising children alone. In fact, statistics say that among single parents, which are primarily females, that most of you have more than one child, and you're raising that child alone. I'm speaking to you specifically because this is something that you need to take care of immediately. Many of you say, I don't have anything. If you work for an employer, yes, you do. You probably have group insurance, and you probably have named beneficiaries. And to create this monster is just absolutely irresponsible. So I want to challenge you, and grandparents, if you're watching this and you know who you are, look at your daughters, because so many of them are females, and look at your grandchildren and recognize that the law is not going to be on your side if you have not taken the necessary steps to ensure that your family stays intact and is financially stable. So that's all I got to say. I'm going to go back to this interview.
Very good.
Thank you.
Excellent.
Did I say it well?
Yes, you did.
I'm so concerned about the number of females that are head of households and do not have husbands or have transient relationships and have these children. And I don't know how the grandparents wind up with these children. This is what I don't quite understand, and I don't understand the issue of the money. So you can explain that to me. If there's no will and the court gets involved, how does that play out, Nancy?
And the children will inherit
Yes.
money?
Yes.
Okay. So, and the children are living with the grandparents at
Well,
that point,
that's the whole issue, because the grandparents many times step in to do this. And I'm sure that we're now into a legal piece, which is, do the grandparents have standing?
Okay.
Because these are not their children per se. But if you could elaborate on that, if that's not too complicated.
No, it's not too complicated.
Okay.
The revised code says that a guardian is appointed pursuant to an application, and the court does not really concern itself initially about who has applied to be appointed as guardian if no one protests. So, for example, if Grandma Mary, if her grandchildren are living with her, and their father dies, leaving a life insurance policy payable to them.
Okay.
They're under 18. Then Grandma Mary could file an application to be appointed as guardian of the estate.
Okay.
And there would be separate applications. There would be an application for each child, so there'd be separate guardianships and separate bonding for each guardianship.
Goodness gracious.
Then upon the filing of the application, certain people have to get notice of that application. The surviving parent would get notice of the hearing to appoint the guardian, and then would have the opportunity to either protest or consent. And so if the surviving parent, and often in grandparent situations, we try to get the consent, certainly decreases the legal fees and the stress.
Yes.
But if we can't get the consent, then there's a hearing to appoint the guardian, and usually the hearing is in front of a magistrate. Montgomery County has fine, very capable magistrates, and the magistrate hears evidence about who is the best to serve as guardian of the estate of these children, and in other words, manage their money.
And all of that could have been avoided.
Yes.
By simply having a properly constructed will.
Yes. Yes.
With guardianship provisions.
Correct. That's correct.
Is one of the things I hear often is, I can't afford somebody like Miss Roberson. Is that a true statement?
It could be.
Okay,
it could be because
okay.
we do charge hourly for our services. And for example, a dialogue about values-based planning can take a couple hours.
Yes.
However, our office has some low-cost packages, very simple packages for people. We believe so much in planning that we have a young adult package, for example.
Oh my goodness, tell me about that.
And that involves a very simple fill-in-the-blank will, a general power of attorney, and health care directives. There's even the ROTR form, which you and I have talked about before, the right of disposition of remains form, which I do want to mention that today.
We want to talk about that.
But just many of the documents are fill-in-the-blank documents that we don't charge a document preparation fee for giving the forms to the people to fill out. And we ask them to fill out the forms, come into our office, and then the staff will meet with them and help them sign the documents. So they won't get values-based estate planning that way, but they will get to put in place very simple documents.
Which is better than nothing.
Yes, yes. And I may irritate some of my colleagues by saying this, but I've always said if if you're going under the knife and you don't have time to talk to a lawyer, or if you've been called overseas for a last-minute business trip, perhaps the office or stationery store form will or the download from the internet would be better than nothing.
Well, I would think in those extenuating circumstances, probably something is better than nothing.
Absolutely. In our office, we get those calls. We know what we can do in a short, when time is limited. Professor Searcy taught us a technique called the warm weather special.
Okay, let me hear this.
And this was in one of our estate planning books, and it was created by a lawyer on Wall Street whose clients would come in on a hot Friday afternoon in July and say, help, help, I'm flying to the Upper Peninsula, I don't have a will, you know, and my plane's leaving in 2 hours, you know. And so this Wall Street lawyer constructed a very simple form will for his clients to complete. And what I've done over the years is created about 8 different variations of that for married people, for single people, single with children, single without children, that sort of thing.
You know, people don't even think about that. I'm thinking about the number of people that do missions work and other things where they're, just recently, one of my close dear friends went to Mexico.
Yes.
And I know she didn't do this. I know she didn't. I know it never occurred to her to do this. And truthfully, it never occurred to me either that she is a single woman with assets, and things happen. Things happen.
They do. We've done, I would say, quite a few last-minute estate plans for missionaries. and I say last minute because, you know, we really like to have time to do the values-based planning, but you know,
if they have to go to Tibet, they have to go to
Tibet.
They
do, and we'll fix them up. You know, it might not be the prettiest that I would like it to look, but it will be adequate.
Right, for the circumstances.
Right.
And then they could come in after they've come back.
Right.
And have it done properly and by the rules.
Yes.
But something, again, it's kind of like that Fram oil, pay me now or pay me later.
It
literally.
Is. Literally.
Pay me now or pay me later. And it seems to me, as I look at the legal system, that if you have not taken care of this, then you're missing the mark, because the judges are attorneys. Probate administrators are usually attorneys. So, and to show up with your affairs not in order is a big hole.
Well, not only that, but it's an issue of stewardship as well, and about, it makes a statement to our families.
I think it does.
You know, I have, my friend Pam Walker and I have run a support group for young widows. This is our 23rd year.
Amazing.
And we actually started a second group for widows over 50, and that group is in its 3rd year. And Pam and I have seen the anger in these young women. Some of it's directed at the law out there, the court system, the lawyer, the judge. The bottom line was that the husband died without a will. They died without adequate life insurance. The particularly hard situations are the blended families.
Oh, yes. Yes, talk about that.
Well, because Ohio law, for example, if there's a blended family and husband dies, let's say there are 4 children, and 2 of them were the wife's biological children, and 2 of them were the husband's biological children, and then husband dies, and he dies without a will and substantial probate assets. Those assets are going to be divided among the wife and the children. I mean, this is even true for a marriage of many years. Now, I'm speaking for Ohio law.
Right.
Other states' laws are different. Other states have what has been called an augmented estate, that for some states the intestate share depends upon the longevity of the marriage. But Ohio's is not like that. So, for example, if husband dies and he has children from a different relationship other than his widow, those children are going to get a substantial part of his estate. The widow is going to get well, and if the children are under 18,
Oh, it becomes
there's
even
an
more.
allowance for support that has to be apportioned between them and the widow. And then the remainder of the estate, the widow gets 1/3 and the children gets 2/3. So, and here the widow has the expectation
That she's going to get it all.
that especially if they've been married for many, many years.
Right,
But
right.
it's not that way.
Now, the 1/3, 2/3 rule is important.
Yes.
Because many people do not know that.
That's right, they
and
don't.
particularly in second marriages and that type of thing.
Yes. Now, I do want to emphasize that if those 4 children were the issue of their marriage, she would get it all.
Right.
It's only if they don't have all the children in common, if he has children from a prior relationship.
So she would get 1/3, and then the 2/3 component would be split among the 4.
Among his children.
His children. Her children are carved out.
That's
Nothing.
correct. That's correct. If they were not also his
Also
children.
by him.
Correct.
Whew. That's significant.
Yes. Oh, yes. And
That's significant. Gosh.
yeah, and I hear, Pam and I heard one night the women were just carrying on at the support group, just ranting and raving about their lawyers and the law and all this stuff. And they don't know that I'm a lawyer.
Oh,
See,
my goodness.
See, I'm undercover. We keep that very quiet
Yes,
because
of
I've
course.
never wanted people to think that I've used the
Yes, of
support
course.
group to get clients. I mean,
Right.
I was a former young widow, and that's why I
Right.
do this. And so Pam looked at me and she said, "You know, it's probably time that you say something." And I said, "Yeah, it is, but I'm not going to introduce myself. You're going to have to lay the groundwork for why I can say what I'm going to say." And so she did, and then their eyes got big as
I'm
saucers,
sure.
you know, and their mouths were hanging open, you know,
Yes.
But that's, you know, part of the angst that goes along with losing a spouse and realizing that there could have been things done differently and they weren't.
And should have been
And
done
should have been
differently.
done differently, yes.
I mean, gosh.
Oh my gosh, and then Michelle, you know how complicated things can get when there's a business involved.
Oh,
We don't even have time to talk about that.
We don't. I just really feel that someone should take any male or his wife, both of them, in that I'm going to spank you mode, because it's just too important today.
Yes. Yes.
And I still remain stunned at the number of people that have not done wills. The statistics are clear, and it's kind of like, well, you are going to die.
Yes.
I don't know when. I don't have a contract that says terms of departure, but it is a fact that when you are born, that you are going to die.
Yes.
And if you have others involved, it is just honorable.
Yes.
That's what it is.
Yes.
Honorable.
Yes, it is.
To have your affairs managed in such a way that it says that you love your family.
That's right. That's right. Now, I want to address an issue that I know that you have faced as well at times, especially when a married couple is doing planning. One may be reluctant. There may be one on board and one is reluctant.
Very often.
And I'll say, look, I'm not trying to create problems in your relationship, but the one of you who is motivated to plan now should do what she or he can do. You know, for example, if husband is reluctant to get a will because of fear or whatever, or can't make a decision about a certain thing, wife should go ahead and do it, because husband and wife are separate legal entities.
Right.
So
Well, actually, I've had these very direct conversations because, truthfully, Nancy, I sit as a female in a male-dominated industry, and many times men have some angst about discussing their situation. The wife is, let's do this, it all makes perfect sense, let's go with it. And then you feel this other pull, which is, it's not going to happen to me. And I'm like, well, moving right along.
Yes, yes.
It's a moving right along kind of a conversation, because she has to be taken care of. She has to take care of her business.
Yes.
And whatever he does, that's on him. Hopefully he'll come to a reasonable conclusion before it's too late. But it is important that women know that they are a separate legal entity and
Yes.
should take care of their affairs appropriately.
Yes.
More so than, in most cases, I've yet to find a situation where the wife is hesitant. This has just been in 30 plus years. It's always been the husband. And I won't tell you some of the outcomes of that because they've not been so good. Because believe it or not, and this is anecdotal, but it is the truth, I literally had to force a couple to get their wills in order. And then I had to force him to get life insurance because he had none. And I had him to purchase, this is many years ago, a $500,000 term policy. Cheap insurance, but they had 3 children and she was a stay-at-home mother. Do you know 2 weeks later he died?
Oh my goodness.
He had a massive heart attack on playing basketball. He was out with the guys and he died. Boom. And I got a call that he had died. And it was just, it could have been so dreadful.
Yes.
But because everything had been put in place, she wound up having a $500,000.
Wow.
Her house was fully paid for. And again, it could have been so different.
What a blessing you were to that family.
I really, and you know what
you.
he said to me? He said, would you leave me alone about this insurance? And I said to him, you have children.
Yes.
You have a stay-at-home wife. I'm not going to leave you alone
Good
because
for
you're
you.
going to sign these
Good for you.
papers. And he did.
So Michelle, one of the things that I've done and I've trained my other lawyers in the office to do, going back to this checklist that we have clients fill out, one of the assets that we ask for disclosure is life insurance. How much life insurance do you have? And if it appears that there is insufficient life insurance, then we will tell the client, go back to your financial advisor if you have one. And many of the people, I would say if the people who come are over 40, they usually do have a financial advisor. If they're under 40, they usually don't, and either they don't need one or they just need a referral for life insurance, for example. We have a form that I've used for many years that helps people calculate how much life insurance they need. When I first started out 25 years ago, and I know you can tell similar stories, I read somewhere where 6 to 8 times the income you're replacing was a pretty good rule of thumb. Well, that's because at that time investments were generating
nice returns.
When I got into this business and started doing probate work, I was handling some CDs, Michelle, that were getting 18% interest.
That must have been in the 70s.
No, it wasn't.
Well,
it was in the late 80s.
Yeah. Okay.
But nowadays, with investments getting a much less rate of return, we need more life insurance.
Yes,
now,
we
thank
do.
goodness, term insurance, especially when one is young and healthy,
Yes.
one can purchase large amounts of term insurance at very reasonable rates. So that's the kind of planning we do as well. And so it's not just about needing a will, you know, it's about, do you have your family covered financially? And then my own situation, when David's health took a turn for the worse, he started getting really sick with couldn't breathe, and this was during his chemotherapy.
Oh, yes.
And he was getting his treatment in Jewish Hospital down in Cincinnati, but his oncologist was on vacation, and so we consulted with an oncologist up here and put him in Miami Valley Hospital, and he just got sicker and sicker.
Oh.
Was put on a respirator, lapsed into a coma, was comatose for 2.5 weeks, and then died. Well, during that time, we had a car that was titled in his name, and the car registration expired.
No.
Yes.
No.
Well, I had no power of attorney.
I was going to ask.
This goes back to consulting with the nice bankruptcy lawyer, you know, because he didn't do estate planning. You know, he didn't know that David was sick. He didn't ask us questions about our health or things. He didn't have a 21-page checklist. But so I didn't have a power of attorney for David. And when it came to making health care decisions for David, David's, he went into crisis twice before he actually died. And I was consulted during those times about the medical procedures. Should we or should we not do this? Well, David was only 28, and I loved him, and I wanted him to live, so I said go for it.
Right.
You know? And after David died, and I did not have health care directives. I didn't have any kind of
And they talked to you without the directives?
Well, they did, because that was 1977.
Oh, okay,
so there
right.
wasn't
HIPAA and all that other stuff. Yeah.
So after David died, our family doctor, who went to our church, he and his wife took me out to dinner, and I was interested to know that he was really agonizing about all the procedures that we authorized for David.
Oh.
He said, he said, we really put him through a lot.
Oh.
And I'm not sure. And it was okay for him to say that to me.
Yes,
I wasn't,
okay.
I could handle that, you know.
Okay.
And I said, I did the best I could.
Right.
You know,
you loved your husband.
I did.
Yeah.
And the only thing that I knew was that he had really good eyesight, and he was proud of his eyes, and he'd written something to the effect that in the event of my untimely death, you know, in the event of like none of us is going to die, like you
right.
said, he wanted to donate his eyes, and unfortunately couldn't do that because what was going on in his lungs was suspected of being maybe Legionnaires, and so they couldn't, was possibly infectious, and they couldn't donate his eyes.
Would you believe that we are almost out of time?
No.
We have not even begun
we
to
haven't.
dig this thing. I wanted quickly, please share with our viewers in the remaining time, because I'm so serious. We have run out of time.
Unbelievable.
About the remains.
All right.
That's important.
The right of disposition of remains is a document that was created in Ohio after Ohio had a case. I like to compare it to the Anna Nicole Smith case.
Okay.
Where, you know, the young actress who died suddenly, and her boyfriend and her lawyer and her mother were fighting over her body. Ohio had a similar case. And as a result of that, the facts were different, but the bottom line is that people were fighting over what to do with this man's body. And now there is a legal document called the right of disposition of remains, in which people can designate. Our form has first, second, and third choices of who will be in charge of your funeral and burial. And that's especially important if you want to be cremated, because the policy of the local funeral homes is to require the consent of the next of kin if you want to be cremated.
That's important.
That's important. And if the next of kin can't agree, you got a problem. So that's why you need to have this right of disposition of remains, or rotor form as we call it for short, in place.
Well, I'm going to say this. If you're watching, Mom, because we had a disputing about this, if you will remember, now you know why. Because she was like, my God, Michelle, all these forms. And I said, well, this form is from Nancy Roberson's office, so I know it's a thorough form, and you're going to sign it. So she was like, oh, nobody's going to fight over my body. I said, you won't be around to know.
That's right.
These things have to be put into place so that things go as per instructions.
So that you can preserve the integrity of your family.
Back to that word.
Yes.
Gosh. Give us a phone number, please.
937-643-2000.
Say it again.
Area code 937-643-2000.
And please, if you're watching or listening or whatever your venue, Nancy Roberson, she's a sharp lady and has my trust and my confidence in her field called estate planning and legacy planning. I'm Michelle Graves. The time went so fast. I will have Nancy on again. I must, because we did not cover a bunch of things I wanted to cover. But I want to thank you, as always, for being a part of my world and allowing me to be a part of yours. In closing, have a wonderful day, and God bless you. You take care.